All right, everyone, let's get started. It's 1:30 p.m. Eastern Standard Time. Hello and welcome to everyone who's joining today's webinar. The title for today's presentation is Liability Claims in Medicare Secondary Payer, Best Practices for 2021 and Beyond. I'm really excited about today's presentation and received a lot of really great feedback that liability claims in Medicare Secondary Payer is somewhat neglected. Seems like there's a lot of focus on workers' compensation in the industry, but certainly liability claims are a significant part of MSP compliance, and I think we have a lot to dig into today. My name is Heather Schwartz Sanderson. I am president of Sanderson Firm PLLC, and I've listed my email address here on the front slide. I do want to go through a few housekeeping items. First of all, and pointing to my email address. If you'd like a copy of today's presentation, or if you would like a recording of today's webinar, I would kindly ask that you actually email me directly and ask for either a copy of the presentation or the recording or both. I'm happy to share it. We do have a record number of attendees on today's webinar, and I did not want to send that out en masse. So please do email me after the presentation if you'd like a recording, the presentation, or if you have questions that are unanswered for today. Another housekeeping item is that after the webinar, there will be a survey that is coming up on your screen after we exit the webinar. It will also come up, I believe, one day after today's webinar. The survey is asking what you thought of today's webinar, what you'd like to hear on future webinars, and also any feedback you might have, and if you'd be interested in hearing more about how Sanderson Firm can assist your organization in MSP compliance. Last housekeeping item, if you have a question, you may populate that in the Q&A chat box up at the top of your Zoom. I will get to as many questions as I can at the end of the presentation. I am planning on leaving time for questions at the end, so I'm hoping to get to those. Again, if I don't get to your question, I will follow up with you via email to respond to that question. For those of you that don't know me, my name is Heather Schwartz Sanderson. I have been in the Medicare secondary payer space for close to 15 years now. I have worked at pretty much all of the major Medicare secondary payer vendors in the space. Just over the last 6 years, I was the chief legal officer at Franco Signor. And just last year, after Franco Signor's acquisition, I decided it was the right time and opportunity for me to step out and start my own consultative boutique style approach to MSP compliance law firm. And just really, really excited about how things have been going this year in 2021. We're growing and really, really just love what I do and love helping folks in all sorts of variety of claims, everything from workers' compensation to general liability and no fault. I really enjoy writing on the topic, so please feel free to subscribe to our blog. I'll provide a link at the end. We do regularly share updates on MSP compliance and what's going on. And also you will be invited to future webinars. And I'll talk a little bit about the PAID Act here in a little bit, but that's something that I was very passionate about and something that I lobbied very hard for last year in 2020. So with that, let's dive in. The presentation is going to be broken up into two major segments. First of all, what I always like to do at the beginning of a webinar is provide a Medicare secondary payer compliance update, like what's been going on in MSP for the past couple of months. And then we'll dive into the meat of the presentation, which is going to focus on liability and MSP. I'm going to try and make sure we leave time for questions. When I was putting together this presentation, I realized there was so much I wanted to discuss. So certainly, if I go too fast and you would like to follow up with me on any point later, please feel free to do so. With that, let's get started. Here's an agenda for today. These are the items we're going to talk about in the MSP update. And also our main segment of the presentation is on liability and Medicare secondary payer, as I mentioned. Let's get into it. All right. So if you've listened to me talk before, if you've read any of my blogs, you've probably heard me talk about MSP Recovery. They're a law firm out of Miami, Florida that is backed by significant private equity. Just recently, they put out a press release that They were acquired by a blank check entity, and they're now worth something around $30 billion, something ridiculous. Anyway, MSP Recovery goes around to Medicare Advantage plans across the country, asking the Medicare Advantage plans to assign their claims to them so that they can bring, typically what they've been bringing are these MSP private cause of action cases for double damages against workers' compensation, general liability, and no-fault insurers or primary plans, if you will, alleging that they failed to reimburse the Medicare Advantage plan. What we have here in this case that I'm discussing here on this slide is something new. So MSP Recovery has now filed a False Claims Act case. False Claims Act is essentially a form of a whistleblower lawsuit, basically alerting the federal government to fraud. So what they're saying is that these 315 auto insurers, so a colleague of mine referred to this case as MSP Recovery versus every auto insurer in America, because it basically is. If your company has auto insurance and you're not named in this lawsuit, then it's a lucky thing for sure. But nonetheless, if successful, this case would allow for MSP Recovery to recover treble damages. They're also alleging that all of these insurers failed to comply with Medicare secondary payer and Section 111 reporting obligations to Medicare, and they're alleging there is this conspiracy. It's pretty wild. We'll see where it goes, but I want to put this on everyone's radar. Certainly, if you receive any correspondence from MSP Recovery, that's something you want to be on high alert about. They are quite litigious, and they are looking to set an example out of insurers. And also, I'm going to talk about it here in a moment about being careful with Medicare Advantage plan conditional payments, as well as Part D conditional payments, because typically MSP Recovery and Medicare Advantage plans have been quite proactive in litigating cases where theoretically the insurers have failed to reimburse the Medicare Advantage plan. The PAID Act is going to help solve a piece of that. So let's move on to that. But nonetheless, if you'd like a copy of this complaint, please email me. I'd be happy to share it. It's very interesting. It's over 200 pages. There's so many defendants. It involves so many parties, but it's definitely something we're going to be keeping an eye on. So I just mentioned the PAID Act. Actually, I've mentioned it a couple of times. So if you're not familiar with the PAID Act, it stands for Provide Accurate Information Directly Act. And now I mentioned that I was quite proactive in lobbying for this legislation because I previously served as an expert on behalf of a large auto carrier that was sued by MSP Recovery. And I also, and thankfully we got that case dismissed, but I've also seen in a lot of cases over the years where my clients have received notices from Medicare Advantage plans post-settlement seeking recovery of conditional payments. And that's no fun, right? Because you think you've settled your case and now you're receiving a post-settlement conditional payment from the Medicare Advantage plan. It was either one of the two. They're either receiving a post-settlement conditional payment letter, or it comes in the form of a lawsuit, like what happened in the MSP Recovery case that I served in. My client, the auto carrier, excuse me, had never received any notice whatsoever that there was a Medicare Advantage plan involved. And yet here they were hit with this double damages lawsuit. They didn't even have an opportunity to repay those liens to the Medicare Advantage plan. They were just hit with a double damages lawsuit. So the reason we needed the PAID Act so much is that currently, if you're reporting through Section 111, you're doing the query response at the beginning, right? So you're typing in the big five: first name, last name, date of birth, gender, and Social Security, right? Social Security number. And you're getting back Medicare enrollment information, right? But right now, all you're getting pre-PAID Act is traditional Medicare Part A and B enrollment. Historically, Medicare has not returned Medicare Advantage or Part D enrollment information in your query response file. So in those situations where insurers who carry either workers' compensation, general liability, or no fault, you're looking to settle a claim with a Medicare beneficiary and you had no idea that a Medicare Advantage plan or a Part D plan was out there that had a claim for conditional payments pre-PAID Act. So the PAID Act was a simple one-page proposal. We got it passed in December 11th of 2020, and it will be implemented December 11th, 2021. And now, as part of your query response file, you will receive Part A, B, C, and D enrollment information so that you can resolve these conditional payments if you so choose pre-settlement. I want to make clear on the different types of Medicare. There's traditional Medicare, Part A and B, administered through the Centers for Medicare and Medicaid Services. And with them, with the conditional payment process, you deal with the Benefits Coordination Recovery Center, the BCRC, or the CRC, right? Medicare Advantage is private Medicare, so that would be United Healthcare or Humana or Cigna. There's almost 4,000 Medicare Advantage plans across the country. And Medicare prescription drug is the prescription drug component, obviously. We're seeing Medicare Advantage enrollment skyrocket year over year due to the fact that generally Medicare Advantage can provide more competitive benefits than traditional Medicare. And also, it's just nice, right? Because if you need prescription drugs and you're on traditional Medicare, you still have to enroll in a Part D plan. So what a lot of these Medicare Advantage plans are doing are offering all-in-one. So if you're a Medicare beneficiary, let's go get all-in-one, our Part C and D, and you have your medical benefit and your prescription drug benefit in one card. So anyway, really nice that come December 11th, 2021, we are going to know of a Medicare beneficiary's enrollment in Medicare Advantage or Part D. It's going to go live on December 11th, as I mentioned, and I want to applaud Centers for Medicare and Medicaid Services for sticking to their timelines. They've already started the testing. They've actually already rolled out They've already rolled out the Part C and D enrollment information to users that report via DDE, the direct data entry, small reporters. And they've been so great in hosting webinars. They hosted 2 webinars, one on June 23rd and one on August 9th. And they're really trying to educate the industry on what's to be expected and what to do, right? So we know the testing period began. Have you all engaged in testing, and how is that going for you so far? I would love to know. But it's important to note, and Medicare discussed some very controversial, I would say, questions on their webinars. What was asked of CMS so many times was, if we receive this Part C and D enrollment information in our query response file, do we have an obligation now to go chase down the Medicare Advantage or Part D plan to determine if they have a conditional payment lien? And Medicare was very clear that no part of the PAID Act requires insurers to go chase down the Medicare Advantage or Part D plan. But I will say, from my perspective, and given the background that I gave you all earlier on MSP recovery and Medicare Advantage plans becoming more litigious, and the fact that you don't necessarily want to receive a Medicare Advantage plan conditional payment post-settlement when you think you've closed your claim down and you think you're done, I believe that it makes sense to act upon this enrollment information and at least see if the Medicare Advantage plan or Part D plan has a conditional payment. Very important, and I'm going to note it again. I know I said it earlier, but I want to be very clear. Traditional CMS recovery processes through the Medicare Secondary Payer Recovery Portal or through the BCRC and the CRC do not handle conditional payment recoveries on behalf of Medicare Advantage and Part D. And they do not intend to, and they probably never will. Medicare was very clear about this. You have to resolve conditional payments directly with the Medicare Advantage plan or Part D plan or their recovery contractor should they use one. So very important. Also, the process is very distinct from Section 11 reporting. Medicare was very clear that you do not have to receive this information, but you probably want to get updated to the most current software. So just take stock. We're 2 months out from PAID Act. What are you all doing to be prepared for the PAID Act is what I'm asking my clients. Do you have best practices in place? What are your adjusters going to do with the Part C and D enrollment information? And it could be that you've decided, well, we're going to just wait and see. We're a little bit risk tolerant. That's fine, but there needs to be a clear, plan and an action plan across your organization, and we'd be happy to assist with that. All right, moving on from PAID Act, let's talk about just recently CMS put out 2 new updates. Briefly just cover the WCMSA reference guide, given the fact that all of you are practicing with liability claims, but Medicare updated their WCMSA reference guide to allow for parties to simply note the funding information as it pertains to a work comp MSA pre-settlement when they submit an MSA to CMS, rather than having to explicitly list the approved WCMSA amount in the proposed settlement documents. Obviously, this was a very good change and a very sensible change by CMS because parties didn't typically know what the total settlement amount or the approved amount is because they're submitting to Medicare pre-settlement. And then as it pertains to the non-group health plan user guide, this is the guide that governs Section 111 reporting, that data transmission that you're doing to Medicare on a quarterly basis, right? So now Medicare has stated that DDE users can now use the beneficiary lookup tool on the Section 111 Coordination of Benefits secure website. And also a really nice development by CMS, they are now allowing, or in situations where the query response file reflects that someone is going to become Medicare eligible within 3 months, you can now update your Section 111 and report, even though the person is not yet a Medicare beneficiary. Just briefly, some new interesting case law involving Medicare secondary payer. This case involved whether a state lien law preempts the Medicare secondary payer law. And there was an argument in the case whether payers should be billing Medicare first and if that would be a violation of the Medicare Secondary Payer Act. But the court concluded that actually the hospital should be billing Medicare first. This is not transforming Medicare into a primary payer, right? That's the whole point of the conditional payment process. Typically, Medicare pays first, and that doesn't mean they're the primary payer. It means that they're paying conditionally subject to reimbursement by a primary payer. This case, the last case and the last component of the MSP update before we dive into the liability segment, I think is a perfect segue because it demonstrates why we need some kind of framework from CMS as to when a liability Medicare set aside might be required. So this was a case out of the District Court of the Middle District of Florida. Medicare beneficiary suffered a slip and fall, and he came to an agreement with the defendants to settle his claim for $200,000. He refused to execute a release agreement, which provided that there would be no MSA, right? And all the parties knew at the time that his future medical care was going to exceed $700,000. So the court analyzed whether an LMSA, so that stands for Liability Medicare Set Aside, was needed. And they determined that given the lack of any regulations or any guidance from Medicare on LMSAs, that one was not required. But interestingly, the court did note that Mr. Stillwell here was unfortunately going to have to probably expend his entire settlement on Medicare covered expenses related to the injury before Medicare would again provide coverage. So this puts the Medicare beneficiary in a bad place, right? Because now his whole settlement is going to future medical. If the parties would have delineated some reasonable portion to future medical out of the settlement, it perhaps would not have subjected the entire settlement to recovery. The other thing I want to note about this case is that the parties had a solidified settlement. I think it was 4 years prior, I believe it was 4 years prior to this decision being rendered, all over whether the need for an LMSA was there or not. Do the parties need an LMSA? I think that if the parties could have discussed the future medical component, the LMSA requirement at the outset, it wouldn't have delayed the settlement so much. So my lesson out of this case is twofold. One, discuss and finalize any future medical decisions that you're going to make as part of a liability settlement. Are you going to delineate some portion for future medical? Let's all be on the same page at the outset so that your case is not slowed down. And secondarily, I do believe that carving out some reasonable, defensible portion of a liability settlement for future medical, where future medical is being released, would help protect the Medicare beneficiary's future benefits and not subject the entire settlement to recovery. But we'll talk a little bit more about LMSAs. I think it's time to dive into our presentation. While you all are here today, let's talk about liability claims and Medicare secondary payer and some best practices for you to take away to your organization. We're going to talk about 4 main buckets. First of all, Section 111 reporting. We're going to talk about the proposed rule that Medicare is working on right now. We're also going to talk about total payment obligation to claimant, TPOC. That is something that comes up a lot of questions on how to properly report TPOC and liability claims. The second component, conditional payments and liability claims, how to best resolve those. We're going to talk about future medical, LMSA considerations, and lastly, your settlement language, which I believe is a crucial part of your MSP compliance and having a solidified settlement. So let's dive right into Section 111. Okay, so you all have likely heard of this scary up to $1,000 per day per claim penalty, civil monetary penalty, also known as CMP, that can be levied against workers' compensation, general liability, and no-fault insurers for failure to comply with Section 111 requirements. We've been talking about this notion for years, and many thought that maybe CMS would never issue a penalty, but lo and behold, on February 18, 2020, CMS announced a proposed rule not only impacting group health plans, but non-group health plans. Non-group health plans by CMS are deemed to be workers' compensation, general liability, and no-fault plans. So the proposed rule specifies how and when CMS must calculate civil monetary penalties and when they would be levied, right? And CMS is statutorily authorized to impose these CMPs under the Medicare Secondary Payer Act, and it's up to $1,000 per day per claim. It's important to note that as part of the Strengthening Medicare and Repaying Taxpayers Act, which was a reform to the Medicare Secondary Payer Act that occurred in 2013, we did modify the language on the civil monetary penalty, which was a good thing, because initially when the law came out, it said insurers were going to be fined $1,000 per day per claim. That was it. That was all. There was no safe harbors. There was no good faith efforts considered. But with the SMART Act, the language changed to up to $1,000 per day per claim. So we need this proposed rule for Medicare to set out what situations they would fine a responsible reporting entity, also known as an RRE. The RRE is you guys. It's the workers' compensation, general liability, and no-fault primary plans. So if I use the word RRE, I hope you know who I'm talking about going forward. So it allows them to apply some discretion, which is a good thing, right? So not a mandatory $1,000 per day per claim. Nonetheless, the proposed rule was very enlightening to the industry. We ended the public comment period in April of 2020. So there was a proposed rule that came out, and the industry was able to comment on it. And Medicare finalized a collection of comments in April of 2020. I believe we submitted some pretty comprehensive feedback to Medicare, as did about 80 different organizations across the country on what Medicare should consider as part of the proposed rule. So now we're going to take a look at what was in the proposed rule so you can get an idea as to the flavor of situations in which Medicare would levy a civil monetary penalty. But it's important to note what the next step is, right? So Medicare put out the proposed rule in February of last year. They closed the comment period of April of last year, and now it is noted on the Office of Information and Regulatory Affairs website that final action is expected to be taken by February of 2023. We've provided a link here to the rulemaking. You can watch its status, and so it will likely be released by February of 2023. And once the final rule is implemented, then CMS can start implementing penalties against non-compliant reporting entities. So now is the time to clean your data up, right? We're approaching the end of 2021, which I can't believe the year has flown by. So this is now your time to clean up your data. But let's take a look at what was in the proposed rule, right? So when the final rule comes out, it might not look exactly like this, but it'll probably look very similar to this. So this is enlightening as to situations where Medicare would impose a penalty. So if the RRE fails to report within 1 year after a TPOC occurs, that would be a penalizing such situation. If their reporting exceeds error tolerance thresholds in any 4 out of 8 consecutive reporting periods, that would also lodge a penalty. And now this third one I think is very important and something that unfortunately occurs often. If your response to a CMS recovery contradicts your Section 111 reporting data. So this happens a lot in workers' compensation, but let's say that you have ongoing responsibility for medical flags, saying that you have responsibility for medical, and then you go to the contractor and say that during that specified time period, you didn't have responsibility, but your Section 111 contradicts, right? I would say also for liability folks with your Section 111 information, make sure your TPOC is correct and accurate. Make sure it's reported within 1 year of it occurring. Most ideally, you're reporting it right away, so you're not potentially receiving a penalty. Make sure those TPOCs are in, they're reported, the claim is closed down, all the appropriate codes are reported. Like I said earlier, now is the time to clean it up before Medicare moves forward with their final rule in 2023. So also another point of interest is that the proposed rule indicated that Medicare is looking to impose a 5-year statute of limitations for civil monetary penalties. Many of you are aware that under the Medicare Secondary Payer Act, Medicare's statute of limitations for conditional payment recovery is actually 3 years. So I know that many folks, including my former organization, submitted comments to Medicare that the statute of limitations should coincide with the MSP and it should be 3 years instead of 5. But we'll see. I think that Medicare is looking to have more time to issue a penalty because it takes time to parse through the data. But the longer the statute of limitations period, the more risk for you all, right? Obviously. So we'll see. Moving on from the Section 111 rulemaking, let's talk about TPOC. What is it and how do you calculate it? So the TPOC is the dollar amount of a settlement, judgment, award, or other payment in addition to or apart from ORM. It's a one-time or lump sum settlement, judgment, or award, and it's intended to resolve or partially resolve a claim. And so I've included here how you calculate TPOC. And this is similar to the calculation for total settlement amount if you're submitting an MSA to CMS on the work comp side, but nonetheless, it includes your Medicare and non-Medicare covered expenses related to the claim, your indemnity, your attorney's fees, the MSA amount, payout totals for the annuities rather than the present values, settlement advances, lien amounts, and amounts forgiven by the carrier insurer. Now you want to make sure your TPOC is accurate. Like I said, that's an important aspect behind Section 111 reporting. You also want to make sure that it's submitted timely. As noted in the proposed rule, if submitted more than a year after it was due to CMS, is potentially a penalizing situation. Get a lot of questions on how to determine the TPOC date. The TPOC date is the date that the payment obligation was established. In other words, it's the date of the signed settlement agreement unless court approval is required. If court approval is required, it's the later of the date of the signed settlement agreement or the date of court approval. And if there is no written agreement, it's the date the payment is issued. Also asked about this one a lot. So if you're dealing with a situation where there is a liability settlement with multiple defendants, right? And perhaps one of the defendants' insurers issue payment in obligation for that settlement, judgment, or award, that does not shift the responsibility to the paying party to only report. All the defendants must report, and they must report the global settlement amount, not just their individual portion or their respective responsibility. The whole settlement amount needs to be reported pursuant to Medicare's guidance. They all remain responsible for their own reporting. In a situation with joint and several liability, similarly, each insurer must report the total settlement, judgment, award, or other payment. It's not just as a signed or proportionate share. What about mass tort scenarios? So this was another question that comes up a lot. So the traditional Section 111 recovery process is not designed for mass tort scenarios. Medicare has set up a special project division for mass tort settlements involving Medicare beneficiaries. It's also known as the AMP program, particularly for asbestos. But what happens there is there's a direct feed with the special projects division where we would be providing to CMS and their special projects division information about the mass tort scenario. And it does create a recovery case. We can't use it only to check Medicare eligibility. It's going to tell us who's on Medicare. We're going to find out if there's any conditional payments owed to the traditional Medicare program. And at that point in time, everything's resolved all in one. The Section 111 obligation and the conditional payments. It's sort of a direct data transfer between the special projects division and the entity settling the case or their agent who's working on the resolution, such as a firm such as mine, helping these parties resolve these obligations. And then at the end, you get a nice letter from CMS saying that all of these items have been resolved. Okay, let's move on from Section 111 reporting and talk about conditional payments. So now, with liability claims with traditional Medicare conditional payments, we are dealing with the Benefits Coordination Recovery Center, the BCRC contractor. Conditional payment letters. So conditional payment letters, also known as CPLs, they provide information on items or services that Medicare has paid conditionally, and the BCRC has identified as being related to a claim. It's typically only issued while a claim is still pending, but not always. It does not need to be requested, but once Medicare is notified of a potential conditional payment issue, a rights and responsibilities letter will be issued to the beneficiary and the primary payer first. And then within 65 days, an initial CPL will be automatically generated and sent to all parties. It's very important to note that you should definitely comb through those conditional payment letters to ensure that only claim-related treatment is listed. This is now the time that you want to start letting Medicare know if you're going to dispute any of the charges. We typically see a lot of unrelated charges in these conditional payment letters due to the technology that is there. Very important. You don't want everything but the kitchen sink that you have to reimburse Medicare. Should only be items and services related to the actual underlying liability injury. And so once the case has settled, you must send in your settlement documents to the BCRC. At that point in time, the BCRC generates a final demand letter when they receive that settlement information. Payment is due within 60 days of the date of the demand letter. And if payment is not received within 60 days of the date of the demand letter, interest is going to be charged from the date of the demand letter. We've also seen an uptick. This is not mentioned in the presentation, but I do want to mention it while I'm here. I just thought of it, is that we've seen an uptick in referrals to the Department of Treasury. So what we're finding is that early on in the dispute process, right after the initial dispute with the BCRC, if perhaps there's some denials to the disputes or some unfavorable response from the BCRC, that a lot of times they're sending these debts directly to the Treasury before payers can exhaust their additional appeal steps. So that's something to be aware of. And if you've received an intent to refer, it's definitely time to act. And if the debt is at the Treasury, all hope is not lost. We can still work with that and perhaps have it taken back. But nonetheless, all the more reason to stay on top of your conditional payment correspondence from CMS. You don't want it to land at Treasury, because once it gets to Treasury, it's not fun to bring it back. And Treasury obviously does not have authority to determine what's related and not related. So let's jump on these conditional payments early. But going back to disputing liability conditional payments, the primary ground for disputing would be relatedness, right? What is the causal relationship of the Medicare treatment to the injury and the underlying claim? The back of the CPL will display the relevant dates of service and ICD codes. And so you can look there to determine what is related and what's not. Medicare also allows for a reduction of the conditional payment lien if the settlement amount is less than the lien amount. This is all codified in 42 CFR 411.37. So if the conditional payment amount exceeds your settlement amount, the maximum that Medicare can recover is the total settlement amount. There's also a process to request a reduction based upon financial hardship, such as the beneficiary's present or future inability to pay. These requests are rarely granted, certainly rare scenarios where the beneficiary has financial hardship. I wanted to highlight this specific case I came across, which shows that the BCRC does recover post-settlement conditional payments. So typically we think of conditional payments as those payments that Medicare has made pre-settlement to which they're owed reimbursement. And then after the settlement, it all goes away. Well, that's not true. Here we have a settlement date of May 8th, 2018. Obviously, we have a large settlement amount of $1.5 million. And if you look down on the bottom of your screen, you'll see here some charges that occurred post-settlement that the BCRC is seeking recovery for. Now, this is something to keep in mind, because if there was a liability Medicare set aside or a future medical allocation that would have been paying for that beneficiary's future Medicare expenses, there wouldn't be post-settlement conditional payments, right? So another reason why it does make sense to carve out some reasonable portion of your settlement for future medical. And I also want to debunk the myth here by showing you a clear case where Medicare has sought to recover post-settlement conditional payments. You don't want to receive these demands post-settlement when you think you've wrapped up your entire settlement and you've closed down the reserves on your claim. So this is a real live case here. Definitely don't forget it. Keep in mind those post-settlement conditional payments. As part of the SMART Act, I mentioned that earlier, primary plans, workers' compensation, general liability, and no-fault plans were now given rights of appeal. Prior to 2013, there were no distinct rights of appeal for primary plans. So nice. This was a nice feature of the the SMART Act, in that it allows a primary plan multiple levels of appeal if they feel that the conditional payment amount is inaccurate. So obviously first, the MAC redetermination would be with the contractor, with the BCRC. The next level is the QIC, and then we can go to an administrative law judge, the Medicare Appeals Council, and United States District Court. I would say most don't go beyond the QIC level. Some do go to the ALJ, and in some cases it's worth it. I'm working on a case for a client. They received a $250,000 conditional payment demand, and only 50,000 or so of it was actually related to the claim. 200,000 of it was unrelated, but unfortunately, due to COVID and whatnot, their organization did not timely respond to the conditional payment. And so they appealed it up to the QIC. The QIC, unfortunately, typically just agrees or disagrees with what the contractor has determined. And in this case, they determined, yeah, the BCRC timely dismissed your dispute because you didn't file a response timely. But it's really not fair, right? I mean, my client should not be held responsible for charges, $200,000 worth of charges that they're not responsible for. And so we're taking that up to the administrative law judge. We're going to have that case heard in January. So it can take a little while to get in front of an administrative law judge, but they typically are not so confined by the constraints of timelines for appeal and such. And they really will look at the merits of the case and only hold a payer responsible for what they're responsible for. So I give this example in a little bit more color to the appeals process because I want to make clear that you're not always without recourse. There's always options. It's important. And in a lot of cases, if there's a large amount that's unrelated and owed, it might make sense to pay the amount in protest and pursue further levels of appeal. And it could definitely save you money. I want to highlight here some final demand calculation options specific to liability claims. These don't exist for workers' compensation and no fault. The fixed percentage option. So this would be a case where you could just self-calculate 25% of the total settlement, directly pay that to Medicare. If the total settlement amount is $5,000 or less, it would save time in the process. You may end up paying more or less depending on what the conditional payment amount is, but that's a nice way to quickly resolve a liability claim that's $5,000 or less. And I believe that a good portion of the liability industry is still using this option for those small cases. There's also this self-calculated conditional payment option. It allows for beneficiaries and their attorneys to self-calculate what's owed to Medicare in settlements, $25,000 or less. I have not heard of this option really being used, and I'd be curious to know if it is being used. I think it's quite difficult, and there's a bunch of restrictions around when it's used, but I wanted to highlight those because those are available to liability plans. And also, I want to talk about Medicare Advantage and Part D conditional payments because I can't complete my discussion on conditional payments and only talk to you about processes with traditional Medicare and the BCRC and ignore what I told you earlier in the presentation, which is that Medicare Advantage is 40% of your Medicare population and Part D is 90% or more of your Medicare population. And they have conditional payment rights too, right? And as I told you all earlier, you cannot resolve Medicare Advantage or Part D conditional payments with the BCRC. They must be resolved with the plans themselves. So keep these in mind. As I mentioned earlier, case law has established that Medicare Advantage plans have a double damages right if they are not reimbursed. There over 3,500 maps across the country. There's over 1,000 Part D plans across the country. And due to the PAID Act coming about in just 2 months, they're probably going to become more aggressive in their recoveries. So more likely to receive conditional payment disputes at these plans as well. What I'm curious about is that I know Humana, Aetna, United Healthcare, and those Medicare Advantage plans are going to be very much ready for the increased volume of calls. These smaller, more regional Medicare Advantage plans, I'm not quite sure if they're aware of the PAID Act and if they're going to be ready. Nonetheless, part of your PAID Act best practices should include a time frame in which, if you don't receive a response on the Medicare Advantage or Part D plan, if they have a conditional payment or not, whether you move on and actually settle your case. But nonetheless, if they do get back to you, which they should, Medicare Advantage plans are much more willing to negotiate, and that's a good thing, whereas the Medicare and the BCRC is much more stringent as far as relatedness and unrelatedness. I've had some great success with offering a Medicare Advantage plan prompt payments where they've significantly reduced the amount owed. So that's really good. They're much more freely to negotiate. What's interesting with the Medicare Advantage plans is that there's no formal appeals process established for disputing conditional payments, just like there is for traditional Medicare. So that is interesting in some respects. I've had situations where I've argued with a Medicare Advantage plan that they are capped at the total settlement amount for recovery of conditional payments, just like traditional Medicare. And they wanted to say they weren't. And I said, well, you can't have all the benefits of being like Medicare, but not the burdens, right? You have to offer appeals, and you have to also stand by the same recovery principles as traditional Medicare. And they relented and they reduced the conditional payment amount. But notwithstanding, there's significant aptitude there to negotiate conditional payments. And we're going to work toward, hopefully in the future, having a more succinct and clear process for handling conditional payment disputes with Medicare Advantage plans and Part D plans, and also a clear right of appeals. Let's talk about what a lot of you probably really want to hear about, right? What do we need to do with future medical or MSA considerations and liability claims? So first of all, it's helpful, I think, to talk about the history of liability Medicare set-asides, the Benson memo. This was the one memo officially that Medicare has put out on liability Medicare set-asides. And they basically stated that you don't need an LMSA if the claimant's treating physician certifies in writing that no further injury-related treatment is necessary. But we have not received any further guidance on this since then. So it certainly tells you the one scenario where you don't need an LMSA, but it doesn't give you the situations where you do need an LMSA. Some of you might recall a decade ago, a memo written by a regional administrator of CMS, Mrs. Sally Stalcup. She provided an informal handout to provide CMS's viewpoint of LMSAs under the MSP. And she noted, while there's no formal process for a review of LMSAs at CMS, the obligation to protect Medicare's future interests under the MSP is the same as in workers' compensation. And she also noted that a distinguishing factor in whether an LMSA is needed hinges on whether the settlement releases future medical obligations. In other words, if the settlement effectively releases the primary plan's obligation to pay for any future medical treatment, you must protect Medicare's interests. And it further noted, CMS does not mandate a specific mechanism to protect Medicare's interests, but an MSA is their preferred mechanism. So I think this was a very enlightening memo. And we've seen additional steps by CMS that they're inching toward a formal LMSA review process, just like they do for workers' compensation. We know that in 2016, when the new contractor took on the WCRC is the Workers' Compensation Review Contractor. They're a private entity that does the review of proposed MSAs for workers' compensation. As part of their contract, they were required to review LMSAs and no-fault MSAs if Medicare were to implement such a program. So the contractor has already agreed legally that they will do so. It's Capital Bridge LLC currently holding that contract. So obviously Medicare put that requirement in there for a reason, right? Also worthwhile to note that there was a GAO study a number of years ago And it advised the acting administrator of CMS that they should develop guidance regarding liability and no-fault set-aside arrangements. So out of this GAO report, we have this push for Medicare to come out with when are LMSAs and no-fault MSAs required. So we got this proposed rulemaking, which I think is very important and very telling. I'll note a couple things about it. First of all, it has been delayed a number of times, and it's currently, if you look it up on the OIRA website, it says it's slated for release this month, October 2021. It would provide guidance on future medical obligations in liability, no fault, and workers' compensation cases pursuant to the description of the proposed rule. And I actually reached out to a contact at CMS yesterday to ask if they could comment on this proposed rule. And they said, obviously they can't give anything to the public, and they can't really say much, but she did indicate that they are actively working on this proposed rule, actively. It will be coming forward. So they're working on it. This is going to come. It may not be this month, but it's going to be soon. And so I believe as a result of the GAO report, Medicare needs to move forward with this proposed rulemaking. What it's going to look like, we don't know. Unlike with the Section 111 rule, where we have a proposed rule and I could tell you what the final rule is probably going to look like, we don't have a proposed rule here yet, right? We need to wait for this proposed rule to come out. So we will see when this does come out. In the meantime, we need to figure out a reasonable way to protect Medicare's interest in liability settlements with Medicare beneficiaries. And I'm going to talk about that in a moment. But nonetheless, here's the abstract of the proposed rule. As I mentioned, it'll impact workers' compensation, general liability, no fault. I'll be curious to see if they change the process for review of MSAs and workers' compensation, given that that process has been in place for 20 years. So we'll see, but we've provided the link here if you want to follow the NPRM, or you can simply subscribe to our blog, because we will be on top of it and let you know of any updates. So what to do now until the rulemaking is released, right? We don't know when it'll come out. As a conservative approach, and I've mentioned this several times throughout the presentation, parties should create a future care plan. If the claimant's going to require future medical care and they're a Medicare beneficiary and future medical is being released, some reasonable carve out for future medical may be warranted, and also protects the rest of the settlement dollars, right? So keep an eye on that proposed rule, come up with some best practices in the interim to reasonably protect Medicare's interest in those settlements of liability claims with Medicare beneficiaries where there's future care involved. I did have a question regarding global settlements involving both a workers' compensation and a liability claim, and I wanted to make sure to address that here. So if you're settling a liability claim that also has a workers' compensation component, the question I get a lot is, do you need an MSA? And so there's a memo that came out a number of years ago in 2003 that addressed this, and so I thought I'd include it here. And it's very clear that third-party liability insurance proceeds are also primary to Medicare. So to the extent that there's a liability settlement that relieves a work comp carrier from future medical expenses, a CMS approved MSA would be appropriate. So if you have a situation where you're resolving a claim, there would be an underlying workers' compensation claim. It would be a workers' compensation MSA in that case, because the underlying claim was workers' comp, and it can be submitted to CMS. And CMS noted that all parties, the liability and the workers' compensation aspect of the claim are all responsible for protecting Medicare's interest. This was not, I don't believe it's included in the current WCMSA reference guide, which is why I had to go back to an old memo, but this would be a situation where an MSP and MSA would be required. Lastly, let's talk about your settlement language. You want to make sure that that's very clear and tied up. You want to address all aspects of Medicare secondary payer compliance, how you address Medicare's interest all throughout your settlement agreement. Particularly, what are the related ICD codes? How are the parties going to handle conditional payments that are known, and perhaps also those that are unknown that might pop up post-settlement? Who is the responsible party? The last thing you want is for your settlement to be blown up due to ambiguity. Also, same thing on the future medical handling. What's going to happen? Is there going to be an MSA, or is there going to be some other future medical allocation? Like I talked about the case earlier on in the presentation, it wasn't clear and it held up the case for 4 years. get everything very clear in your settlement agreement. You should have your agreed and accepted ICD codes within the settlement agreement. And also, so the parties are on the same page as to what codes are included. And also, primary payer should verify if plaintiff's counsel has reported different codes to the BCRC. This happens a lot where plaintiff's counsel self-reports to the BCRC, and then the RRE or the liability payer reports via Section 11 and the codes are different. This confuses Medicare, and we again want to make sure we're all on the same page as to what's related. Conditional payments, what's owed and which party is responsible for reimbursement, known and unknown, right? And there's a couple of different ways to do this, right? A direct payment by the primary payer to Medicare, that's preferred, or a direct payment by the plaintiff or plaintiff attorney. This is okay, and this happens a lot in liability settlements where the plaintiff attorney agrees to be responsible, but it is important to note that if the plaintiff or plaintiff attorney does not reimburse the Medicare program, Medicare does have the right to switch the debtor and pursue any party to the settlement for recovery. Some parties have done a joint check to Medicare and the plaintiff. This can cause problems procedurally. There's a potential for unenforceable settlement in bad faith. We've cited a case here where this was a problem. So a direct payment is the most preferable option. Also, if there's a future medical plan, it should be detailed in the settlement documents, including the amount, the funding structure, and the method of administration. And if there is no future medical care plan, the settlement documents should discuss why it is not appropriate. And it may be appropriate to consult with an expert. It's also worthwhile to consult with an expert in MSP on your settlement language in general, and just to make sure that you're tying up all of your MSP obligations within. So in essence, wrapping up today's presentation, liability and best practices for MSP can be summarized in 4 steps. First, determine whether the claim involves a Medicare beneficiary or proposed potential future Medicare beneficiary. And if they are currently on Medicare, let's investigate, negotiate, and resolve the conditional payments in the claim. And this also includes Medicare Advantage and Part D conditional payments. Address the conditional payment reimbursement issue in the settlement agreement and be specific as to how any future unknown conditional payments will be addressed. And determine whether the nature of the injury claimed is likely to involve future Medicare covered care. If so, outline how the settlement will protect Medicare's future interests. You may want to include a waiver, the plaintiff waiving their private cause of action right under the MSP. That's that double damages, scary provision in the Medicare Secondary Payer Act that has been used in a lot of cases. So lastly, just a quick plug-in for Sanderson Firm and how we can help your organization. We'd love to hear from you. We'd love to help. We offer liability Medicare set-asides. We also have an indemnified legal compromise LMSA product. If you'd like more information, please reach out to hear more about that. We also have great success in helping our clients navigate conditional payments, verifying them, disputing them, and appealing them. A lot of experience at Sanderson Firm doing so, and great success there. Also settlement agreement review, making sure that all your MSP obligations are tied up. We've been consulting with folks too on Section 111 reporting and how to get your best practices in place, not only just trying to get in a position where you wouldn't be subject to civil monetary penalties, but also getting ready for the PAID Act. We can also provide legal opinion letters and just overall best practice improvement on Medicare secondary payer. I have provided my email address here again, also our website, and would really love it if you all could sign up to our blog and future webinars. Go to contact and subscribe on our website, sandersoncomp.com. Now we've got 7 minutes left. So let's go, and we have a bunch of questions. So let's get to some questions before we wrap up. Okay. What's the proper response or way to handle when the claimant and or their attorney refuse to provide the social security number? It's hard to comply with Section 111 if they won't cooperate. This was an excellent question. Thank you so much. I actually should have covered this in the presentation. This happens a lot in liability claims, right? You're not able to get a social security number. The Medicare beneficiary or their attorney might feel that this is protected and they don't realize there's Section 111 obligations. Well, first of all, I would explain to them why you need the social, and I could help you with a form letter that would go out to your Medicare beneficiaries or prospective Medicare beneficiaries and their attorneys explaining why this information is needed for you to comply with Section 111. If they still won't provide their Social Security number, there's a form. It's known in the industry as the CMS affidavit. And actually, just recently, Medicare updated the form to have the claimant include whether they have been eligible for Medicare generally. It used to just say Medicare Part A or B. Now they've given it general to all types of Medicare, which I think is great. Nonetheless, the form has the claimant certify that they were refusing to provide their Social Security number. And it is something that you can use to document your file that you have attempted to obtain their Social Security number and they have refused, and they're putting this in writing. As part of the proposed rule that Medicare is working on for Section 111 civil monetary penalties, they did set forth a 3-step process that they want RREs to undergo. It involves mailing the plaintiff twice and also trying to reach them by email or phone. And they're going to require that you can demonstrate that you underwent all these steps to try and obtain a plaintiff's Social Security number. That has not been implemented yet. I just want to say that more stringent rules around collection of Social Security numbers are coming. But for now, a form letter to the Medicare beneficiary or their attorney explaining why you need the social to comply with Section 111. And then if they still refuse to provide, filling out the CMS affidavit. So this person asking this question or anybody else that's interested in more information on this, I can provide you with that CMS affidavit and also can assist with coming up with a form letter to plaintiff attorneys to explain why you need the Social Security number. Moving on to the next question. How can an RRE ensure they receive a copy of the conditional payment letter or demand for liability claims? By submitting a consent to release at the onset of our claim. That's right. So we would need a letter of, I believe it's a letter of authority signed by the Medicare beneficiary. So the way that Medicare does is they typically put the debtor as the Medicare beneficiary in liability claims. And so to gain access of the conditional payment letter or demand letter, we would need a letter of authority. And once we do that, you'll be able to see all the detail and get all of the conditional payment correspondence. And please feel free to reach out to me if you have more questions about that form. Next question. If the RRE has proper lien language on the release, then Medicare should not be able to pursue the post-settlement conditional payment against the RRE. Is that correct? Unfortunately, that is not correct. Your settlement language is helpful, but it's not an ironclad defense. So let's say your settlement language does specifically state that the plaintiff and their attorney are responsible for any post-settlement conditional payments. Typically, Medicare will pursue recovery to the plaintiff or their attorney. But let's say that they come after the liability RRE, you would still be responsible to reimburse Medicare because Medicare is not a party to your settlement agreement. But then hopefully you have indemnification language in your settlement agreement, which allows you, the liability RRE, to now recoup what you had to pay Medicare as part of your settlement agreement from the plaintiff or their attorney due to the fact that they contractually agreed to reimburse you. So the lien language in your settlement agreement is important. I just want to point out that it's not ironclad and that Medicare does still nonetheless have a responsibility and an ability to recover from any party to the settlement, regardless of settlement language. Next question, and we're running close to out of time. So many good questions today. What should you do if you know there's an Advantage plan, but then Medicare sends you a letter stating there's no conditional payment? That's an excellent question, right? So I would actually say that's a red flag to know that a Medicare Advantage plan has a claim for conditional payments. If traditional Medicare is telling you that their conditional payment amount is 0, that is a clear sign that there has been a Medicare Advantage plan there. That's great. So you don't owe the traditional Medicare program anything, and you would simply want to resolve those Medicare Advantage plan conditional payments with the Medicare Advantage plan, because in this situation, you know that the Medicare Advantage plan has been paying and not traditional Medicare. So that's what you should do, is go to that Medicare Advantage plan. Medicare is going to close down their claim file because they have not paid anything. One more question, and then we're going to wrap up. What recourse is there to the claimant, notwithstanding to the PAID Act? They know that they are a beneficiary and have a duty to reimburse. Recourse to the claimant. So as I mentioned, if there's not a future medical allocation, the plaintiff potentially could have to expend their entire settlement on Medicare covered expenses related to the injury before Medicare will provide coverage. And as it pertains to conditional payments, I'm not sure what this question was regarding specifically, but if it pertains to conditional payments, Medicare does have a right to recoup some of those settlement dollars from the beneficiary or their attorney to resolve conditional payments. So with that, I think yes, it is 2:30 Eastern time. So we still have so many questions. I'm going to respond to all these via email. If I didn't get your question and you still have a question, please email me directly. I really want to thank everyone for participating here today. There was so much to talk about. We'll have to do a liability and MSP part 2 because there was a lot more to dig into here today, but I hope today's session was helpful. Thanks again, and I hope everyone has a great week. Bye-bye.